So I'm dealing with investigations and examinations, and there are 3 cases on that slide. I'm going to leave Comment Group to later on in the talk and deal with the Mitchell and Al Jaber case, which went to the Court of Appeal from Mrs. Justice Joanna Smith. And this is a case under Section 236 of a private examination. And at first instance, Mrs. Justice Joanna Smith held that immunity did not apply to the oral and written submissions made in Section 236 examinations. And so if you gave permission to the liquidators to re-amend their re-amended points of claim to include pleadings of varying loss and damage as a result of breach of fiduciary duty, unlawful means conspiracy and so forth, which arose from some of the statements that had been made during the private examination, which was said to have been false. The Court of Appeal disagreed and found that affording immunity to examinees under Section 236 would not actually materially cut across the principle that those who suffer a wrong should have a right to remedy. And they made the point that in most cases, a liquidator would actually seek information prior to an examination under Section 235. And if the examinee was an officer of the company, they would also be under an additional statutory duty to provide information. And therefore, even if the examinee enjoyed immunity from statements made, it would not protect them from an action based on non-disclosure or non-cooperation in relation to those duties. The Court of Appeal also pointed out that a liquidator can rely on statements made under Section 236, under Section 433 of the Insolvency Act. And so the liquidator may still obtain a remedy via that route. So effectively, the Court of Appeal did allow immunity from suit, but made it clear that the liquidator can still use Section 433 to refer to and rely on the examination. And of course, are always entitled to plead a claim based upon failure to disclose. It seems to me that this case raises the issue of how far does that immunity go? Can it be an argument deployed by an application to submit that at the first stage under Section 236, which is to seek that examination, to say the court can order that examination because it cannot be oppressive and unfair because there's immunity from suit. Those words, oppressive and unfair, are of course part of the discretionary test to be applied by the court in considering the balance to be struck, whether to exercise its discretion to make an order under Section 236. In effect, the court balances the reasonable need of the office holder against unfairness or oppression. The case confirms that those are the principles under which the court acts in deciding whether to order an examination under 236. And also reiterated the point, there is no privilege against self-incrimination under Section 236 in an examination. Effectively, the question there arises, seems to me, that can the information, if the information cannot be used to plead or form the basis of a claim, then it is perhaps limited to the mere provision of false information, which can't form the basis of a claim. But in fact, the answers relied upon, answers given can be relied upon generally by an office holder to pursue their cause of action.
I'm going to deal with this subject. As you can probably see from the title and from the number of cases on the slide, it's simply not going to be possible to deal with this in any great detail. It's an area that continues to be a hot topic and will continue to be a hot topic until there is authority from one of the higher courts. However, what I do want to do is just remind you of some of the issues that are in play and to give you a pointer towards a very helpful recent decision where there's a full analysis of the point, and also to point to the way in which the cases seem to be going. So the starting point is a reminder of the important case of Euromaster. Remind you of that because that forms the bedrock really of the thinking that still continues to underplay the court's thinking. So Euromaster was the decision of Mr. Justice Norris, and it was concerned with an appointment which was made 11 business days after the filing of the notice of intention to appoint, when paragraph 28(2) of Schedule B1 provides that the administrator may not be appointed under paragraph 22 after a period of 10 business days, beginning with the date the notice is filed in paragraph 27(1). The judge applied, and you'll hear this throughout all the authorities, the so-called Sonegi approach That's from a case called the Crown and Sonegi, and it's really an approach, it's not an insolvency case, it's an approach to construction of statute and construction of the general principles of construction. What the Judge Norris concluded, Mr. Justice Norris concluded, was that weight should be given to, first of all, the object of out-of-court appointments being to streamline the process of business rescue. Secondly, that it's highly undesirable to have a multiplicity of circumstances in which the appointment of the administrator is automatically invalidated. And thirdly, that Schedule B1 contains certain provisions which are naturally read as defining the circumstances in which the appointment arises, and some are read as prescribing procedural requirements that must be fulfilled before the appointment's properly made. He concluded that paragraph 28 was part of the group of sections which set out procedural requirements for the exercise of the power, and that was strongly suggestible. I think strongly is overstating it. In fact, I think he accepted it was that there were strong arguments the other way. But it was suggestive of the fact that the court should treat the appointment as being irregular and not null. That decision of Mr. Justice Norris in Euromaster was followed almost immediately by Mr. Justice Etherton when he was Chancellor in a case called Re Melodious. But bringing it up to date position, the recent cases I want to draw your attention to are, first of all, a case called Re Token House. It's a very careful decision of Insolvency and Companies Court Judge Jones, concerned with a failure to comply with paragraph 26(1). He identified the problem as being a tension between the normal meaning of the wording, which generally tends to suggest the appointment that non-compliance should render the appointment ineffective, and B, the disproportionate effect when compared with the prejudice caused by the breach. So that tension is one which was played out in that case. He opted, as indeed we'll see most of the other judges have when called on to deal with this, for the appointment not being invalid and in effect found that it could be cured. In a case called ARG Mansfield, a decision of His Honour Judge Davis White QC sitting in Leeds, and I ought to say we should have subtitled this talk The Davis White Show, because you'll see his name appears in many of the cases in this. He applied essentially the same approach, the so-called Sonegi approach to the statutory interpretation. There's then a further case called Re Arlington Infrastructure Limited, a decision of of Andrew Sutcliffe QC sitting as a judge of the High Court. The issue there was that junior creditors had not received the written consent of senior creditors to the appointment of the administrators in circumstances where there was a deed of priority requiring them to do so. So the qualifying floating charges were not enforceable, and there had not been compliance with paragraph 16. The judge there, the deputy judge, followed the reasoning in Euromaster, but held that it was a nullity. And that perhaps stands out. So it is important that you realise that there are still decisions going either way. There's then a decision in NMUL Realizations Limited, which is a decision of Deputy Judge Frith. And again, you might wonder what the distinction is between that and the case I've just described. There, the failure of the debenture holder, there was a failure of the debenture holder to serve notice of intention to appoint on the holder of prior security. Under paragraph 15, that meant he nevertheless said it was an irregularity which could be remedied under Rule 1264. It was not void ab initio. And again, he followed Token House. So you see that there's a pattern here. I want to add, and this is an example of a case where, an example of a slide where you should add another case for your note, a case called Zoom UK Distribution Limited, which is 2021 EWHC 800. That's a decision of Stuart Isaacs QC sitting as a deputy judge. There, the breach was paragraph 26. Because there'd been a failure to give written notice to qualifying floating charge holders of the proposal. He held that it was not fundamental, and where applying the Synergy approach, no injustice had been caused, then it could be cured. So he, in turn, applied Token House, Euromaster, and NMUL. So on these, whilst the matter remains a live issue, as you can see from the number of cases, what I suggest is that there is a consistent pattern developing of applying Euromaster and the subsequent decisions, albeit not always with the same outcome, because the test is fact sensitive, particularly around that second limb of prejudice. I'm going to hand over to Lucy to deal in one slide with the topic of pre-packs.
Lesley, I'll be fairly brief in relation to this, just to note the administration restrictions on disposal, etc., to connected persons regulations 2021, which came into force on the 30th of April of this year. The regulations apply only to administrations after that date. In effect, they require that under Regulation 3, that an administrator cannot make a substantial disposal to a connected party unless either there is approval from the creditors or what's called a qualifying report. The creditor approval requires itself that the proposed disposal was in the administrator's proposal, and also that the decision has subsequently been approved by all creditors following a copy of that being sent to them. A qualifying report is the different situation where a connected party has to obtain from an independent evaluator under Regulations 6 to 9, which set out the consideration to be paid for the relevant property and whether or not the grounds for the substantial disposal are reasonable in the circumstances. And it's important to point out the regulations make clear that this independent evaluator has to set out in the report various matters such as their professional ability to provide that report, insurance and so forth. It's quite specific as to the information that has to be provided. And what they have to set out is whether or not the substantial disposal, the grounds are reasonable in the circumstances. In other words, it's perfectly possible for that report to conclude that the grounds and the consideration are not reasonable in the circumstances. The regulations also go on to say that in either case, whatever is contained within that qualifying report, that report has to state the reasons for the statement and the evidence or reference to the evidence on which that evaluator relies. That qualifying report has to be sent to every creditor. It's worth noting that it also has to be made clear that if that connected person has already got a qualifying report, and one can perhaps envisage a situation where there is one that's been obtained which isn't perhaps to the liking of that connected person, the subsequent evaluator has to refer to that previous report in their report and has to proceed on the basis that it is correct unless he believes it not to be correct. It does raise a question of how that is then dealt with. But in essence, that is now what is required. So they're quite prescriptive regulations for making sure that the proposed disposal is transparent and also in effect evaluated by someone who is wholly independent, and previous information is made clear to the creditors of the company.
Thanks, Lucy. I'm going to pick up on some other aspects of administration and then deal with two of the cases on this slide, the first and second one. The Wesley and another one, you'll see cunningly, I have managed to also have the Zoom reference there, but in a slightly different format. So that is the Zoom case that I've just asked you to add to the previous slide I was talking about. Excuse me. The Moulds Fencing and Butler decision. This is another decision of His Honour Judge Davis White, QC, so it's his second mention in dispatches from me. It also featured our own, by that I mean King's Chamber's own star, Eleanor Temple, who unfortunately can't be here today because she has other commitments. It concerned the hierarchy of objectives in relation to a company and administration under Schedule B1, paragraph 3.1. Essentially what the judge held, or the bit that's of interest, we think, for you, our listeners, is that the third objective of realising property in order to make a distribution to secured or preferential creditors could properly be pursued, even if unsecured creditors will also receive or might also receive a distribution. It was an application by the administrator of a well-known construction company. Again, it's sometimes known as Retailer Pearson Construction Limited, and they're the clue as to the identity of the company being a major construction company. It was an application by the administrators to make a distribution to the company's unsecured creditors. 12 creditors, however, applied for revocation of the administrator's proposals and or for the company to be placed into liquidation. The company had been badly affected by COVID, which made, and again, COVID, I'm afraid it's not the first appearance that COVID is making in the course of the seminar today, as you won't be surprised to learn. The company had been badly affected by COVID. It made achievement of Objective A, rescuing as a going concern, unlikely. Objective B couldn't really be pursued because the one substantial piece of work in progress that was thought to be capable of completion at the outset within the administration turned out not to be financially viable according to a surveyor's report. So Objective C was instead intended to be pursued on the basis that the company's assets could be realised and a full distribution made to the preferentials and a dividend to the unsecured creditor. The objections were broadly as follows. Firstly, it was said it should always have been, this was the creditor's objections, it should always have gone into liquidation, not administration. Secondly, it was said that Objective C would cause unnecessary harm to the creditors. Thirdly, it was said that it couldn't be pursued where there was a prospect of distribution to the unsecured as well as preferential creditors. And finally, there was an argument that there was a failure to seek creditors' approval, or that a creditor's approval should be sought. These arguments were all, in effect, rejected. The first objection, namely that the company should have gone into liquidation rather than administration, was not surprisingly rejected because there was no application pursuant to Rule 358. The second argument about harm was rejected essentially on the facts. But importantly, and we think this is the point that's of some interest, is that the third ground, namely that you couldn't pursue Objective C if there was also going to be a benefit to the unsecured creditors, was also rejected. Finally, it was said there was no approval required because the case fell squarely within paragraph 52(1)(c). So an interesting decision on the hierarchy of objectives. The second decision I want to deal with briefly, I'm going to tantalisingly, as I say, leave Arboretum Devon out so that you can all go. This is the first thing you'll do when you come off the seminar, is obviously go and look and see what that one's about. The Madurgo Cardiff's quite an interesting one. We're in, again, I'm afraid Brexit, of course, or exit from the EU has to feature, of course, in these talks. Post the UK transitional period, the issues arose about retrospective administration orders and the proceedings being opened on the date of the order, not retrospectively. And it also raises a question, which I think featured in one of the questions earlier on, about the recitals that you have to have in the order under Rule 313 of the Insolvency rules. So the essential factual position, I don't want to overlabour this, the administrator's term had expired in January 2020, but had been extended for another year by creditor consent, albeit arguably that consent was invalid. Unaware of that, a further extension, or unaware of that point, a further extension to January 2022 was ordered. And assuming that their appointment had ended or might have ended in January 2020, the administrators sought retrospective extension of their office. So the issue was whether it was possible to extend the original administration order with retrospective effect, or to make multiple administrative orders with retrospective effect, and if so, what the appropriate recitals were. Now, a word of caution, some of these points were dealt with without really being full argument on the side. There was only one party in attendance, as I recall. Again, it's a decision of, it's on Davis White. he held that the court did have jurisdiction to make a retrospective appointment, and that was following the ARG Mansfield case that I referred to in one of the earlier slides. But, he said, paragraph 77(1)(b) prevented the court from retrospectively extending the period of administration once it had expired, and that was a mandatory provision. Any application pursuant to paragraph 76(2)(b) had to be made by the administrator. And if the period of office had already expired, then he or she had no standing. So there was no power, effectively, to make an order dating back more than 364 days, and it couldn't be extended by using the device of a further retrospective order. What he ordered, in fact, was an order made for 364 days, which extended the appointment to the 17th of January 22. However, and this is the reason, it's not just another effective type appointment case or retrospective validation point. The court made certain observations that if the order was made after the close of the transition period for withdrawal of the UK from the EU, then the proceedings were probably opened on the date the order was made rather than the date the order took effect. And so it did have to contain the recitals in Rule 313 of the 2016 rules as amended by the EU exit regulation. So although these were observations, probably an indication as to how a court would decide the point after full argument. I hand back to Lucy to deal with CVAs.
Thank you very much, Lesley. An area where CVAs have become increasingly subject to challenge on the grounds of unfair prejudice is where a sector of creditors, and recently this seems to be typically landlords, are proposed within the arrangement to have restrictions either on the amount they can recover for the method of which they can recover rent, which isn't going to be paid in the future, or the amount of that. Now, Lesley and Caraway were two cases that were heard effectively consecutively by Mr. Justice Zaccaroli, and counsel from each were entitled to sit in the other case. They both dealt with the point which had arisen in discovery against Debenhams, which was effectively, how is it possible to sidestep the question of unfair prejudice where particular sectors of creditors are going to be treated manifestly differently? Now, the Lesley case concerned New Look, the store's New Look, which inevitably had a variety of landlords of properties with different functions. So, for example, there were landlords who were landlords of properties for wholesale, those for retail, high street shops, etc. The proposal itself had no less than 4 different categories which separated the landlords of the properties into various categories. Other creditors came within even more different categories of creditors. And in essence, the complaint was that for the purposes of the CVA, certain groups of landlords were going to be treated inevitably far less favourably. Importantly, Mr. Justice Zaccaroli confirmed that it is, of course, perfectly possible for a CVA to provide for different treatments of different groups of creditors, even if that treatment is significant or substantial. And he pulled out a number of key points. An important consideration, firstly, is whether there is a fair allocation of the assets available within the CVA between the compromised creditors and other subgroups of creditors. And that will include considering the source of the assets from which the treatment of the different subgroups derives, and whether they would or could have been available to all creditors in the relevant alternative. Secondly, an important consideration is the nature and extent of the different treatment, the justification for that treatment, and its impact on the outcome of the meeting. There would be strong grounds to conclude it was unfairly prejudicial, where a CVA which compromises the claims of a subgroup of creditors is achieved only because of the votes of a large swathe of creditors who are unaffected by the CVA, even if there's an objective justification for those creditors being unaffected by the CVA. Third, it's also relevant to have regard to the extent to which others in the same position as the objecting creditors approved the CVA. And fourth, a finding of unfair prejudice ought not to be precluded merely because the same result might have been achieved in a Part 26 scheme of arrangement plan. So that is an important case for furthering the perhaps increasing situation where different groups of creditors, particularly landlords, are to be in effect prejudiced, but it's permissible for that to be prejudice and it's not to be unfair prejudice. The other case I just want to focus on in detail is the TXU case. It's useful guidance as to not so much the unfair prejudice at the start of a CVA by way of a challenge to it, but as to the court's approaches to the issue of prejudice in completing a CVA. And an important point arises about the ability to conclude a voluntary arrangement, even though there are unanticipated contingent creditors which will be left outstanding. In the TXU case, the supervisor was permitted to conclude the CVA and distribute on the basis that it was found there would not be any special unfair prejudice to these contingent creditors. And the court said there seems to me to be no special prejudice to these contingent creditors in carrying through the voluntary arrangement. There's a benefit in doing that and in allowing a final distribution because it will allow payment to meet creditors of other companies with the group. And the reality was, of course, acknowledged that the longer the arrangement went on, the less money there would be. And in fact, that would not be to the benefit of any contingent creditor either. Back to Lesley.
Thank you, Lucy. I'm not going to say a massive amount about this because you have already had something about some of the winding up principles already this morning. I just want to draw your attention to a couple of things. And again, if I could, I probably should have put on the slide the Travel Lodge case, which again, just for your benefit, it was one of the more well-known ones that was reported back in 2020, and already in these post-COVID-19 days, what seems to be a long period in normal life seems to have zipped by swimmingly. The Travel Lodge reference, just so you have it, is 2020 EWHC 1217. I want to focus, though, briefly on the PGH decision, just because it's, again, if you want the decision to go to look at what the proper approach to this. So we're now talking about the application of the coronavirus test in circumstances where that remained relevant. And essentially, although it's a decision of Judge Kelly sitting in Leeds. I don't know why all these cases come to Leeds. I think they must be really litigious there. Judge Kelly actually sets out a very helpful analysis of the way to approach this, in particular around the operation of the two stages to the burden of proof. So what she said was there's a two-stage approach. The debtor company has the evidential burden of showing that coronavirus has had a financial effect on it before the winding up petition was presented. This was intended to be a low threshold. The company didn't have to establish that the pandemic had caused its insolvency. The second limb of the test was the shifting of the burden to the petitioning creditor to demonstrate that if the financial effect of coronavirus was ignored, the company would still be insolvent within the meaning of the Insolvency Act, Section 123. Under Schedule 10 of the 2020 Act, and you'll appreciate you've already picked up the fact that the Schedule 10 has been amended, but the court had to determine whether the company would be unable to pay its debts as they fell due if coronavirus had not had a financial effect on it before the presentation of the petition. And for it to answer that question in the affirmative, the judge said, the petitioning creditor needed to demonstrate that the company would still have incurred the debt and been unable to pay it. The mere fact that and this is perhaps stating the obvious, but the mere fact that the debt arose after the commencement of the pandemic was not sufficient to demonstrate it. So quite a useful case on the burden of proof. And of course, I ought to have mentioned again that the case featured, and indeed the successful party, was our own Nick Taylor.
Macclesfield Town Football Club is quite an interesting case on how the relevant test to apply, and in particular how to approach the evidence to be gained and put before the court for a retrospective validation order under Section 127. This was a case where between presentation of the petition and the winding up order being made, peer-to-peer lending had been taken and security given to the lender, in effect, to try and help alleviate the problems which the club was facing. The case confirms that the approach to the necessary evidence to be obtained differs fundamentally from a prospective validation order. And it's useful in respect of that guidance. In particular, of course, with a retrospective application, the approach is not to ask, had it been made prospectively, would it have been made? And that's perhaps an area which isn't obvious, that one might have thought that in the same way, looking at a prospective validation order, what is the likely benefit to be obtained? Is it going to benefit the creditors overall? One might think for a retrospective validation order, one would simply try and apply that test as to whether it would have been ordered and validated had it been made prospectively. But the court said no. And the court says, court effectively acknowledged that this is a case where hindsight has to be used, and the evidence which needs to be put before the court would need to demonstrate in simple terms that the transactions in question had not been prejudicial to creditors, had not dissipated the assets for those creditors, and had in fact provided benefits for those creditors. And so the approach was not to effectively say, would the court have ordered it had it been made previously? The court was able to conclude that the loan agreement and the charge had been entered into in good faith, in the genuine belief it would assist the company to trade and increase in the value of the company's assets. And that, again, is a material point in applying the test for the relevant evidence. It's to apply hindsight and look at what has actually happened, but also to examine the motives and the beliefs of the company and those behind it when the transactions were entered into. Perhaps two other points to note. First, the fact that the transactions had been deliberately entered into with knowledge of the petition didn't affect the assessment of the evidence as to the value which the transactions had obtained. There was nothing inherently wrong in that, because the lending and the charge had been entered into in good faith. And another point to note was this, in fact, was a case where I think there had been 2 or possibly 3 prospective Section 127 applications previously. And it's a point perhaps to bear in mind. There was, of course, no bar to a later application being made for a retrospective one. It wasn't suggested that all of the transactions should have been subject to one application under Section 127 at the time.
Thanks, Lucy, into a completely different area. So the next 2 slides set out a number of cases where essentially the new provisions in Part 26A of the Companies Act 2006 are applying. And so we're into the realm now of schemes of arrangement and restructuring. That came in force in June 2020. So there's been about a year or just over a year of it being in force. And there has been an really quite lively activity. Not so much, I haven't been able to find one where His Honour Judge Malcolm Davis Malcolm Davis White has been involved in it. But in this instance, it's Mr. Justice Trower who appears to be particularly active. You remember there isn't scope in the course of this to go over the actual provisions, but I hope all of you will remember that this was the new court-sanctioned restructuring tool, which had the important difference that it was possible to cram down dissenting classes of creditors. The cases that we've seen so far have, by and large, but not exclusively, focused on the identification of the appropriate classes and the identifying criteria by which they should form membership of that particular class. So there has been quite significant use of the tool. It's perhaps worth noting at the outset that as you will see from the names, these are all well-known high street, very large multinationals or type of companies. What I don't think we're seeing is evidence, or not seeing yet, and any feedback on this would be quite interesting in the chat function, actually. What we're not really seeing is it being used particularly by small and medium enterprises. But in any event, let me just give you a flavour of the sorts of issues that are arising in these cases, because the issues won't be different. The application, of course, will be. So Virgin Atlantic Airways Limited, no need to introduce who this is about. Again, this is a decision of Mr. Justice Trower. And there were 4 proposed classes of creditors for the purpose of the restructure. Firstly, lenders under a secured credit facility. Secondly, lessors of 24 aircraft. Thirdly, connected parties who were creditors under various agreements with the company. And fourthly, certain unsecured trade creditors. Mr. Justice Trower essentially applied the same sort of criteria to class composition for these purposes as would be applied to a scheme of arrangement. In other words, the court looks at whether the legal rights to be released or varied under the scheme, or the new rights to be given under the scheme, are so distinct that the scheme has to be treated as a compromise or arrangement with more than one class of creditor or member. So just pausing there, so that's quite a long sentence. You're looking essentially therefore at the rights and the legal rights and the way in which they've been affected. If the rights are so dissimilar as to make it impossible for the creditor as a class to consult together, then a separate class should be created. So essentially what Mr. Justice Trower said was that the same sort of principles apply to Part 26A. In the case of Pizza Express financing, Alistair Norris, Queen's Counsel, so Mr. Justice Norris, as he was now in retirement, essentially took the same approach. There were 3 classes. Firstly, a plan member company holding all the company shares. Secondly, the holders of senior secured loan notes. And thirdly, holders of senior unsecured loan notes. So you get an idea as to what the sort of degree of precision which is necessary for the consideration of the court. Gate Group Guarantee, which is a case on if we just pop to the next slide, Lucy. Gate Group Guarantee was a decision of Mr. Justice Zaccaroli, and it had initially been proposed that there should just be one class of creditors for senior lenders and bondholders. The court drew on the analysis in Virgin and said that that was inappropriate and that, in fact, there should be 2 classes. I want just a brief foray away from class identification, just to draw your attention to a case called Smile Telecoms Limited. Again, a decision of Mr. Justice Trower, but dealing with an issue of essentially an overseas company. So the issue was whether a Mauritian incorporated holding company of an African telecoms firm had sufficient connection to the jurisdiction. He held that it did in circumstances where, firstly, the liabilities to the proposed plan creditors were almost all governed by English law and with English jurisdiction clauses. Secondly, where on the facts, the company had actually shifted its COMI to England in June the previous year because it had moved its administrative offices to London. And finally, it had registered at Companies House as a foreign establishment. And finally, it had also had an English bank account. So you can see the sorts of considerations that apply to, in other contexts, when you're establishing whether the company has sufficient connection with this jurisdiction, also apply to schemes of arrangement and restructuring under Part 26. Finally, I want to just mention the Amicus finance decision, a decision this time of Mr. Justice Snowden, and an interesting one because it draws together the fact that these restructuring schemes are not confined to the company or its directors itself. In Amicus, a very recent decision in August earlier this year, the administrators of a property finance company themselves put forward a plan for restructuring to enable it to exit administration and return to solvency to be operated as a going concern, a very rare event in most of our work, the company returning to solvency. The position was that the company had provided short-term property finance with the majority of its loans being funded through a trust structure. The trust enabled funding vehicles to fund loans on terms whereby they retained the beneficial interest in the loan and the company just held the legal title. The company went into administration in December 2018, and the administrators considered that it was no longer viable or in the interests of the creditors of the company to remain in administration because the loan portfolio had proved to be more challenging and expensive to service than had originally been anticipated. The company was or would be immediately cash flow insolvent. And so the administrators considered that a Part 26A restructuring plan was the only alternative to liquidation. The original convening hearing, you recall that this is done in stages, was adjourned in the light of objections which had been raised by a security trustee on behalf of 418 individual lenders. The security trustee argued that the proposal for a single class of creditors was wrong, and that either it should be in a class of its own, representing, remember, the 418, or that another creditor, which we'll call H, should be entitled to vote in the same class, but only up to the value of the debts held by the security trustee. They also argued that the accompanying plan for the restructure was inadequate because it didn't consider an assessment of the alternative returns that would apply in liquidation. The court essentially held that both of the conditions required to be satisfied were indeed satisfied here. So condition A in the section requires it to be shown that the company had encountered or was likely to encounter financial difficulties which were affecting its ability to carry on business as a going concern. And he also said condition B applied because the proposal was a compromise or arrangement with the company's creditors or a class of them. On class composition, the judge also held that although the same general principles of class composition applied to Part 26A as applied to Part 26 schemes, you recall that was the schemes of arrangement as they originally were before Part 26A. So he said, although the same general principles applied, a rigid application of them might not always be appropriate to Part 26A type plans. He applied the Virgin Atlantic and Virgin Active decisions and said the correct approach there was to focus on the rights the creditors possess, not their identity. And he directed that the security trustee creditors could form, or security trustee on behalf of the creditors, could form a single class in respect of their secured claims up to the value of the senior debt, and that the creditor H should form a separate class in respect of the balance of the claim. Sorry, I slightly expressed that. The first class was H, the creditor, plus the security trustee up to the value of the security trustee's senior debt. The separate class was H for the balance of its claim. On the question of the adequacy of the information, the court was satisfied that there was sufficient information in the accompanying explanatory statement to enable creditors to be able to take a view on the merits. And he applied the decision in Sunbird Business Services Limited, which is a 2020 decision, EWHC 2493, and Virgin Active. Interestingly, as a final observation, he also awarded the security trustee the costs of the application to reflect, firstly, the fact that they'd succeeded by and large in relation to the class composition argument, and also generally because of the contribution they'd made to assisting the court in the process of identifying the classes.
Assignment of causes of action. The first, the Oasis case, and the reference to section 246ZD by way of background. Of course, prior to the insertion of section 246 into the Insolvency Act, there was the limit to the causes of action that insolvency office holders could assign to third parties. In particular, it was thought that although they could assign rights of action which vested in and formed part of the assets of the company, such as misfeasance claims, they could not assign the statutory rights of action which were conferred upon them simply by dint of their office holding. For example, fraudulent trading, section 213, wrongful trading, transactions to under value, and so forth. And that view came from the Oasis merchandising case. Section 246ZD was inserted into the Act and effectively changed that so that those claims can, in fact, and are, of course, now capable of assignment if there was any ever any doubt about that. The case of Cage Consultants was where the liquidator of the company had assigned the cause of action. And since the assignment, the company had then been struck off and dissolved. It was argued that there was a fundamental difficulty with the assignee pursuing those claims after the company had been dissolved, because under the terms of Section 213, 238, etc., the court is only empowered to order a respondent to the application to make a contribution to the assets of the company or make some other order which would have the effect of restoring the position. And so what was argued was if the company had ceased to exist, even where the office holder had assigned the cause of action under Section 246, so as to be capable of being pursued by the third party rather than the office holder, any order resulting from the proceedings could only be made in favour of the company or to restore the position of the company. And therefore, what was argued was until restoration of the company to the register, the claim by the assignee would have to therefore be dismissed or stayed unless and until that company was ever restored to the register. Mr. Justice Snowden on appeal confirmed the decision of District Judge Matheru in Manchester and rejected that approach and stated it was quite clear that Section 246 allows assignment of the proceeds of such a claim. The company does not therefore receive them or even have to exist. And he went on to say that the approach that was argued for would, in fact, frustrate the clear legislative purpose, as it would mean an assignee could only pursue a claim for the purpose of obtaining an order that the proceeds should then be paid back to the company. And yet they would have to bear the costs of pursuing the claim, but wouldn't obtain a direct benefit, but would somehow have to be dependent upon receiving a distribution of part of the proceeds through the insolvency process. The next two cases I just want to mention are Taunton Logs and Manolete Partners. They're procedural cases which deal with the procedural matter of whether a liquidator or assignee of statutory causes of action uses a Part 7 claim form or in an insolvency application, and the extent to which insolvency claims can be subject to an insolvency application. In the Manolete case, Chief Judge Briggs said that a claim under 212, which of course is for misfeasance, breach of duty by the directors, can only be brought under that gateway by the liquidator or the office holder. Section 246 does not include claims vested in the insolvent company, and a claim for breach of fiduciary duty has always been a claim of the company, even though an assignee takes the beneficial interest in that claim. It can't be brought under Section 212 because the assignee will never be a creditor, contributory, or an office holder. Section 246 gives the assignee of a creditor standing to make an application using the gateway of those statutory causes of action. But the office of liquidator and that of official receiver can never be assigned or sold. And so the reality is that an assignee of a claim which the company always had will be entitled to bring that claim in its own name or the name of the company. But Section 212, which is effectively the exclusive gateway for an office holder, cannot permit an application to be made under that gateway. Effectively, therefore, such a claim brought by an assignee or any other claim which has always been a claim vested in the company could not be brought as an insolvency application. Because for an insolvency application to be brought, it would have to be one which the office holder could bring. And effectively, the court said, and this follows a similar decision in Taunton Logs as to a different cause of action, that even though it should always have been brought by Part 7 rather than an insolvency application, the court could order that the claims could continue as insolvency applications as they had been issued on conditions. And the two main conditions were that there'd been no abuse of process in using the wrong procedure. And of course, perhaps more importantly, that the issue fee, which would have had to have been paid on a Part 7 claim form, would of course have to be paid. The important point to bear in mind is before bringing a claim, whether as an assignee or otherwise, it's important to bear in mind that not all claims arising from an insolvency can be made within an insolvency application. Edengate Holmes perhaps reiterates what a creditor needs to show to challenge an assignment of a cause of action by the liquidator. The key facts were that the applicant who challenged the actions of the liquidator under section 1685 happened to be the defendant, or her family happened to be the defendant in the proposed assigned claim. So there was clearly, one might say, an obvious conflict in trying to challenge what had happened, which would inevitably allow the assignee to run the claims. The an applicant under section 168 has to show a legitimate interest in the relief, which is aligned to the interests of the creditors as a whole. It's not permissible for one disgruntled creditor to simply challenge the decision and the actions of the liquidator in making that assignment. And the court held that the fact that the applicant had obvious and plain separate personal reasons to challenge the assignment meant that that threshold could quite simply not be met. The case also reiterates that what has to be shown is a high threshold, that the liquidator's decision to assign was perverse, and that was emphasised as being a formidable threshold that an aggrieved party has to meet. And it amounts to effectively saying that the court should find the conduct of that liquidator was such that no reasonable person could have behaved in that way. So the court would have to substitute its own judgment. And that was found to be a threshold which would rarely be achieved. Moving away from any whiff of COVID or Brexit, one doesn't often get cases on champity and maintenance, but this was one. An interesting case, again, relating to assignment, that Hugh James Involegal was an assignee of causes of action of negligence, which administrators had assigned. It's a rather convoluted background to how that claim arose. The assignor company had been defendant in group litigation, Transform Medical Group, litigation brought by groups of claimants claiming negligence for, I think, reconstructive surgery. The claimants for those claimants, that their lead solicitors had not been informed that the defendant was not in fact insured for some of those claims. And so the defendant company ultimately claimed that its own legal advisors had been negligent in failing to advise it to give notification to the opposition solicitors that it wasn't insured to meet some of those claims. That claim was assigned to Involegal, which effectively was simply an entity of those lead solicitors. In other words, the solicitors on the other side who felt aggrieved and wanted to recover the unpaid costs it had incurred in representing uninsured claimants, could never recover the costs of so acting. What was argued was the first point, and it was on a summary judgment application, that the assignment did not come within the Nor-Glenn exception, which of course that assignment of causes of action in return for a share of the proceeds is permissible by liquidators and trustees in bankruptcy, because it's not just a bare right to litigate. What was said was this assignment was to what was termed as an artificial creditor, who was simply seeking to recover the costs that it had incurred in previous litigation. And that was true in reality. However, what was important to note that the term of the assignment did in fact provide that sums of money would be due to the administrators under the assignment, even though it was a tiny percentage of the potential recoveries. The court held it was not a requirement to come within the Nor-Glenn exception, that the assignment has to be made to a creditor. What is required is that the assignment made is to be to someone who is willing to take the proceedings in his own name, and that the benefit to the creditors is a fixed sum or a share of profits which they might not otherwise have. And in this case, despite the existence of a wholly artificial creditor, there was a fixed sum plus a percentage of net recoveries. And although extremely small, the key point was that those sums were those which would not otherwise have been available to the creditors, because the administrators would never have carried on with the proceedings. And so the court held that there was a realistic prospect that that assignment, however artificial it may have been, was precisely what was within the contemplation of Lord Hoffman in Nor-Glenn. I pass back to Lesley.
Thanks, Lucy. We're nearly there, folks. Just keep going, keep going, keep going. Right, a brief word about directors' powers and duties. There's one slide on, there's one case on there that I actually had involvement in, and in keeping with the general tradition that we only talk about cases where we were successful, I'm going to say absolutely nothing about keeping kids company, other than to draw your attention to the fact that it exists, for those of you who don't, and it was an interesting decision on charity trustee directors. Instead, I'm going to talk about the other cases on the slide. Hunt and Mitchie, an interesting point. We can deal with it very shortly, but it raised a quite interesting point. It was a case where the company had been placed into administration, later converted into a CVL, and the company had later been dissolved and then restored. There were claims brought against, essentially against the former director of the company, Mr. Mitchie, and two of them related to the extent to which his duties under the Companies Act continued during the insolvency process. So essentially that was the point at issue as to what was the impact of the insolvency process on the general duties in section 170 to 177 of the Companies Act 2006. It was argued by the respondents, not surprisingly, that once a company enters into administration or CVL, the general duties only survive in respect of the exercise by that director of powers qua director, preserved by or permitted in accordance with the Insolvency Act 1986. So what it does raise quite an interesting point. The court rejected that argument on the behalf of the respondent, saying this really: the general duties extend beyond the exercise of powers as a director, because a director is, for example, required to avoid conflict of interest, which is not dependent on the exercise of any given power, qua director. Secondly, they said, considering the Companies Act as a whole, when provisions were intended not to apply in administration or compulsory liquidation or CVL, it stated expressly in terms that that's the position. Thirdly, it was said, a director's duties are based on common law rules and equitable principles, and so should be interpreted and applied in the same way. And it was said that the principles themselves are sufficiently flexible to extend beyond the start of the insolvency process. And finally, it was pointed out that section 172(3) expressly preserves the duties of a director in certain circumstances to consider or act in the interests of creditors of the company. Finally, the judge relied on the formal aspect, namely that the directors remain in office. So an interesting one on that point. The next case, PSV in Langdon, is a case, it's also known as Rediscovery Yachts. And again, an interesting one for those to refresh your memory in relation to the problem of redesignating monies taken by company directors. Sorry, no, I've got those the wrong way around. It's the Bronya Buchanan case that deals with that principle. So that was a case where an action was brought against a sole director of a company. She was ultimately ordered to repay to the company some £286,000, which she had taken out as, quotes, drawings, but which she retrospectively sought to characterise as remuneration. And you may recall there's been quite a few cases on this, and it's something that I have to say you frequently encounter in practice, both as a practicing barrister and solicitor and a judge. In other words, we often have clients who seek to redesignate matters when it suits them. The payments in this case did not appear in the company's annual accounts as either salary or dividends. It was found on the balance of probabilities that she had probably taken them on account of future anticipated dividends, hoping that the company would ultimately make enough money to declare dividends that would cancel them out. But perhaps unsurprisingly on this one, Judge Burton said it's not open to the directors to recreate history. I like that phrase. It's not open to them to recreate history, and the basis on which they've historically received company monies or made retrospective accounting adjustments to change the nature of the sums received. And in doing so, they followed a decision in Jones 2020 decision. So that's quite an interesting one. The Discovery Yachts case, is the one, the PSV in Langdon that I started to talk about. That's a different point, but also I think quite a useful practical point. So where a company's liability for a debt had been established in court proceedings, the court said it automatically establishes the personal liability for the debt of a director pursuant to the Insolvency Act, Section 217, where the individual had been involved in the management of the company in contravention of Section 216. And that was held to be so, even where there was no contravention of Section 216, when the contract which ultimately gave rise to the debt was entered into. So again, a small point, but one that is of some practical significance. At that point, I hand back to Lucy to pick up on office holders' duties.
Lesley, and I will shorten this from what I was going to say, given I'm conscious that we're already running over. The Urel Kali was a very bitter failed bidder for a sale of a company by its administrators, and tried everything to criticise what the administrators had done to found a claim in negligence. It's quite useful guidance from the court as to what a prospective purchaser, one of the bidders, would have to establish to show that the administrators ever owed a duty of care to prospective bidders. And in short, the court confirmed that the status of administrators is as agents. There's nothing without more that gives rise to any assumption of responsibility to bidders. They're there to appoint and administer a company's affairs, and they do so without owing a duty of care unless there is more than that to a particular creditor. Secondly, they do not assume a personal responsibility to bidders by undertaking the sales process, again, without more, and without more would have to be significantly more. They are acting solely as agents in promoting a rescue. There's no duty to act like an auctioneer, and that was one of the arguments run by the claimant, that somehow they were effectively like an auctioneer. And the court rejected that and said some special circumstance or factor would have to be shown to prove that an administrator owed a duty of care, and there was simply nothing that came within that category in the case. And the court reiterated warning that to impose a personal duty of care would severely constrain the ability of administrators to perform their functions single-mindedly in the interest of creditors, would inhibit that ability to respond and act quickly. It also made the point that if there was a duty of care, then administrators would have to, in conducting a sales process, would have to deal with determined and well-funded suitors under the veiled threats of personal liability if they didn't do what was asked of them. The second case, the Comic Group, and in fact the citation for this was given on one of the earlier slides. It's a 2018 case. It's a very unusual application, and the facts are unlikely to come before the court again. But it was an application by liquidators who'd been administrators seeking directions of the court under Section 112 as to how they should treat an issue concerning a disputed validity of a debenture. It had arisen because of a disgruntled director of the company, the Comic Group, had complained to the professional body of the liquidators, the Institute of Chartered Accountants, as to how they were dealing with the issue. That resulted in the Institute providing advice and various notes and expressing clear views as to what hadn't happened and what the administrators and liquidators should have done. The underlying criticism was that in accepting the appointment, the administrators had failed to identify and evaluate the potential threats to their objectivity. What is interesting about the case is not the facts of what the criticisms were, but the fact that Sir Nicholas Warren declined to give the liquidators the protection which they sought, which of course is usually that office holders have to take commercial ones to act reasonably and responsibly based on legal advice. Nothing controversial about that. What is interesting is the court analysed in detail the various complaints which had been made and the responses to them, and found there was a justified perception that the liquidators might be compromised. What he ordered, there was no application for a new liquidator, but what he ordered was that an independent third party would need to be appointed to investigate the potential claims against directors. That was one of the points which was levelled at the liquidators as something they hadn't properly investigated. He also expressed the view that the liquidators should not make payments which were a result of the disputed charge, and they did so at their own risk. Effectively, what happened, therefore, was that the court gave directions the liquidators should make an application for an appointment of a conflict liquidator to act in concert with them in determining issues which there was at least an argument that they were not wholly impartial as to. I'll move back to Lesley.
Lucy, I think we can miss on Stanford the list of time. It was a brave attempt to try to extend the scope of duties owed by a bank, and it failed. So back to you to I think round off then.
Again, very, very briefly, Rule 1411 is, of course, an application that can be made to exclude a proof of debt. The office holder can apply where it's been improperly admitted, or a creditor or member can apply where the office holder has not properly intervened. The point is a very straightforward one from the Paragon case and has nothing to do with the particular facts of the underlying claim. What hadn't actually been established by the applicant was that there'd been a proof of debt at all. And the court emphasised there has to be a proof of debt which has been lodged by the creditor to even engage the Rule 1411 and a challenge to be made. And the court made the clear point. There's no requirement for a creditor to submit a proof of debt. And if there hasn't been a proof upon which an adjudication has actually been made, there is no jurisdiction and no power to challenge a creditor's claim under Rule 1411. A point perhaps to bear in mind: if there is a challenge to a claim by a creditor, it can't be made under this rule unless there has actually been a proof of debt.
All right, well, I think we'll draw a close there. You've got the slides and you can see that we were going to go on to just make some observations about a couple of other points, but the slides are there. There's nothing there. On behalf of Lucy and myself, can I just thank you all for staying the course? I mean, I think you have all stayed, or at least you've all continued connected to the call. Whether you've actually been listening is another matter, but we thank you for listening, and we haven't got time for questions, but if anybody does want to raise anything, then of course you know how to contact us directly through our email. Thanks, everybody.
Thank you.